Ladies and gentlemen, welcome to the Summers Zoning Commission. This is a special meeting on Tuesday, January 21st, 2020. Starting from my left, we have Dan Ferrero, Paige Rassett, Carl Walton, myself, Jill Conklin, Jennifer Roy, our staff liaison, and Glenn Charlder is with us from Planometrics. This is a continuation of a public hearing. This public hearing is number 1916, Town of Summers Zoning Commission, adoption of revised regulations. Also application number 1917, Town of Summers Zoning Commission, adoption revised zoning maps. What we're going to do is, if you have new information that you'd like to address, you can come forward, put your name and address, and speak into the microphone. To start, we're going to have Glenn from Planometrics bring us up to speed from the questions that were addressed, or the questions or concerns that were addressed at our last public hearing. Yeah, probably.
Whoa.
Good one.
Nope.
Testing, no?
I don't know.
Is it on mute?
That's the one that's staticky.
Try that.
There we go. Good evening, Commission. I'm Glenn Charlder from Planometrics. Had the pleasure of working with the Commission over the last year and a half or so in terms of updating the zoning regulations. Last week, on January 13th, I believe, we opened a public hearing on the regulations. I gave a short presentation, a PowerPoint, in terms of the nature of the changes in the regulations, the organization of the new regulations, the work that we had done. There were a number of public comments that were delivered. I have compiled those comments into a spreadsheet type configuration and organized them by section of the regulation. So hopefully this will make it easier for the Commission to go through the regulation section by section and evaluate the comments. So I think that if for any reason people who were here tonight or were here last week and had misrepresented their comments, please tonight, if you would correct that for the record, I'd appreciate it. I think the Commission would as well. And other than that, Madam Chair, I turn it back to you in terms of any additional public comment or input that may come forward.
Sure. And the issues that were addressed last public hearing, there's copies here if anybody would like a copy. So with that said, we're going to go ahead and let anybody that would like to come up and add anything new or a question that they might. Whenever you want. And actually, before that, we're going to have Jennifer Roy. She has some correspondence.
Okay, the following written correspondence was received in opposition. Ken Pryor of Mountain Road has deep concerns about the proposed regulations allowing breweries, wineries, and distilleries in a residential zone. Thomas Nesbitt is writing in opposition. He lives at the corner of Mountain Road and Turnpike. He's concerned about traffic. Tom and Sue Wasco, 192 Turnpike Road, are opposed to allowing wineries in the residential zone. Eleanor Levine, 9 Mountain Road, strongly opposed. She also lives at the corner of Turnpike and Mountain. Deborah Stone, 6 Mulberry Lane, is very concerned with the zoning regulations to allow a winery on Mountain Road, concerned about use of pesticides and long-term effects on the neighbors, concerned about additional water usage to grow crops, and concerned about traffic. And the following written correspondence is in favor. I did have this letter hand-delivered today. He did request that I read the first 2 paragraphs. So, from Kenneth Coelho. Dear Commission members, I have reviewed the draft regulation and do have some concerns with Section 6 referencing winery, brewery, distillery in residential districts. Section 6.12 and other supporting sections are vague and lack basic guidelines and standards to ensure the location of these activities that do not negatively affect the areas they are located in. For that reason, I oppose the proposed regulations. I also oppose 52 banquet and wedding events per year at any location, as that would be a primary use and is excessive. I have reviewed the Farm Winery Act of 1978, Public Act 294, and other documents, and found they clarify what is lacking in these proposed regulations. I would support a regulation for a winery, brewery, distillery if the regulation had the proper language that would protect the residential district first. I support wine festivals and other activity related to the primary use. It should also be understood that all potential locations are not the same or site-specific and will not always be granted the same allowable activities. Then I have a letter jointly signed by neighbors on Hall Hill Road, Nancy Rodriguez and Eric Meisterling Jr., 646 Hall Hill Road, Eric Meisterling Sr., 44 Goodwin Drive, Hyman Rabinowitz, 634 Hall Hill Road. They are in favor of the proposed zoning regulations and zoning map. Tracy Eisman, 85 Michelle Drive, support of wineries. Judith LaValle, in support of wineries. Melissa Termel, 31 Hickory Drive, in favor of wineries. Angela Kohler, support of wineries, 43 Sunshine Farms Drive. Cindy Reynolds, 37 Isabella Drive, support of proposed wineries in Summers. Caroline and Chris Skronik, 36 Gristmill Terrace. They support wineries in town, also suggesting support for consumption and tastings on site. They are concerned about traffic, but they don't feel it's a major concern, same as attending a rock concert and other mass flow of vehicles. Kelly Gacello, 118 Stafford Road, in support of wineries, including on-site consumption. Christine Anderson, 11 Evergreen Lane, in support of wineries. Dawn Cuvier, 24 Hillcrest Drive, in support of wineries. Aaron Tynan, 48 Michelle Drive, in support of wineries. I already read that one. It'll be hard to duplicate. Did I say Kimberly Radowitz?
No.
Okay. Kimberly Radzowitz, 48 Juniper Hill. She is in support of wineries and supporting on-site sampling and consumption. Kristen Foy, 20 Bradfield Drive. She is in support of wineries. Heidi McCarthy, 40 Florida Road, in support of wineries. The letter here dated January 15. I don't believe I received this last week, August the 13th. Okay. This is from, dear members, it's from the Summers Republican Town Committee. At the most recent meeting of the Summers Republican Town Committee on Wednesday, January 8, 2020, Spider Carey presented a motion that the RTC support the application for use for a permit. Oh, this is for next week, actually.
Yep.
Scratch that. Then also I submitted to the commission a detailed letter from Sean Clark of Kenny, Brimmer, and Mahoney, LLC, outlining some suggested language for wineries in section 611 and 612. That should be.
Now we'll open it up to the public.
Good evening. Good evening, John Parks here on behalf of Sunny's Place.
You can take it out, John.
You can take it out or
Take it out if it's
make it
easier.
taller,
Make it-
whatever you need, John.
Good evening, John Parks, here tonight on behalf of Sunny's Place. I do think, Glenn, you got the comments right, at least regarding what we were interested in. And frankly, if the language at the top of the second page was adopted by the commission, I would sit down and shut up. Basically, that the CR zone would be deleted from the proposed regulation, and golf center could be added back into section 3.2 as allowed with a special use permit in the zone. I won't repeat the reasons that I mentioned last week because that would be repetitive, and Joe wants to keep it the new thing, which makes perfect sense. But what occurred to me after the meeting, even after I read Glenn's summary here, and many of the changes he made came closer to what we wanted, but it doesn't quite get there. And some of the concerns that we have that we didn't mention last time is that there still is a component in that regulation for a master plan, and probably 80% of Sunny's Place has already been developed. And normally, when you see a master plan, it's at the beginning, not at the end. And the idea of a new regulation roping in these items that have been approved for, 20 years or more, it doesn't make any sense. I think it puts the cart in front of the horse and is a further problem. In addition, the scheduling of the special events still poses a problem, and I think we've addressed that previously. With me here tonight is Tim Kuhn from J.R. Russo and Associates, Jonathan Murray, and Jerry Antonacci, and if they have anything further to add, they can, but those are my points.
Thank you.
Hi, Mark Murdoch, 24 Gulf Road. Just want to add some comments from last week. It appears that we had a lot of support for wineries in town, and conversely, there were a number of people, emails received today, and I count 6 last week that voiced some opposition to wineries. But it appears that each of these people were residents in the Mountain Road area, and obviously have some reservations about a potential winery opening up nearby, and may have had a negative experience in the past. As you know, however, this is a meeting that's about allowing wineries and breweries in the town of Somers as a whole, and not just about Mountain Road.
Mhm.
So as I understand it, the special permitting process is the time at which specific property applications should be considered, or are considered. May I therefore suggest for the zoning commission to proceed with the zoning regulation changes as amended to allow for on-site consumption and for specific issues with the Mountain Road to be addressed when and if a special permit is reviewed. In this way, I believe that most, if not all, Somers residents' concerns and comments are met. And in addition, I'm confident that any concerns about Mountain Road residents can and will be worked out at that time.
Thank you.
Thank you. Snooze you lose.
Good evening. My name is Tom Nesbitt. I live at the corner of Mountain Road and Battle Street. I did send an email to Mrs. Roy with regard to the winery. I'm not necessarily against wineries in town, but I think that the board needs to be a little bit more careful in where they allow wineries to occur, especially if there's going to be tasting. Mountain Road was recently improved by the town at great expense, and it was not widened, it was not straightened. There is plenty of traffic on that road right now, and if there is a winery on that road, it's going to increase the traffic. And having seen the location of a very serious accident in New York State 2 years ago, where 17 people in a limousine were killed, on a downgrade where the driver missed a stop sign, I think it's important that the board reconsider where they will allow the use and the permitting of a winery in town, so that there are other aspects taken into consideration for those locations, specifically traffic. And Mountain Road is already busy enough, and as I mentioned in my email, when Mr. Keeney came by to try to pay for my vote to the town selectmen, we had a conversation. We were standing face to face, and the traffic was such that we couldn't carry on a conversation without serious interruption because there was so much traffic at that intersection. I have a letter here from Mrs. Griswold, who lives on the corner of Battle Street, that she would like presented into the record. To the zoning commissioners, I received a notice about the proposed winery on Mountain Road, and if I could, I would attend your meeting on the 13th, but I am 93 years old and can't do it.
There is no proposed winery on Mountain Road.
There is not an application before us for anything on Mountain Road as far as the winery goes. This regulation is a regulation that may or may not be adopted into our regulations that would allow a winery in town, not any specific area of town.
Well,
and that would be a special use permit, and then that's when these issues would be brought up.
Very well, but I still think that the board should reconsider where they're going to allow wineries to be permitted.
Because it's a public hearing, I'm not going to comment right now. I just wanted to clarify that. We're going to continue, and we can address that when we have a discussion. Thank you.
I'm on your list.
Yes, you are.
I'm Dwight Merriam. I'm a lawyer with offices at 80 Latimer Lane in Simsbury, and I have been retained by Hillsdale College to review the proposed new regulations. I have consulted with my colleague of many years, Dan Dalton of Detroit, who represents Hillsdale College in Michigan, and he will be getting permission to join me as co-counsel in the next few days. With me this evening also is Frank Fish, this gentleman to my right. Frank Fish is a professional planner, and he will have some brief testimony. I think we may need not more than 15 minutes of your time to put on the record what we want to put on the record and to explain what we believe the issues are with regard to your regulations. Frank Fish is not only an expert planner, but he is a member of the American Institute of Certified Planners, and also one of a very few, I think there are only 4 in Connecticut, for example, a fellow of the College of the American Institute of Certified Planners, the very highest certification that one can have. My remarks this evening are organized around 4 general subjects.
Yep. Okay.
And I have an outline for you that you can follow along. And I will be talking about these regulations with regard to the Connecticut General Statutes. These regulations, first I'll start off with talking about the federal law that some of you have heard about already, the Religious Land Use and Institutionalized Persons Act, because that's what Hillsdale College is most concerned about, and that's what I've been focusing on in my review of this proposal. And then state statutes, then the Connecticut Constitution, then the U.S. Constitution. There are lots of issues with this draft, and I can't touch on them all, but I can give you some illustrations where I think there are very serious, in fact, insurmountable problems. Now, Connecticut is a record appeal state, so that whatever goes on during the hearing, as you know as well as I, is all the record that's available for review later. So I need to put a few documents into the record, and I hope you'll indulge me as I do that. This is entitled Hillsdale College Appendix of Representative Documents affirming Hillsdale College's Christian identity and mission. And the relevance of this is the fact that Hillsdale College is a property owner in this town, and it does have a religious mission. So I'd like this appendix to be made a part of your record.
Should I give it to her?
No, I don't.
Well, eventually
Well-
we'll get it.
You can receive it and mark it as received.
I also have Hillsdale College entitled 175 Years of Learning, Character, Faith, and Freedom, talking about some of their programs, which are matters of religious celebration and matters of religious institutions. I also have a short document merely entitled History, about the history of Hillsdale College, documenting its religious purposes. I have a 2-page article entitled Hillsdale College Celebrates 175 Years with Christ Chapel Dedication, again dealing with their religious mission. Now, you may find this odd, but I'll get to it. I have a 2-page web copy of Sonny's Place, because believe it or not, there's an issue regarding religious freedom as to the regulations you propose for that area. There's also a problem with the sign regulations. I'm a planner and lawyer. I work all over. I work for planning and zoning commissions as well as property owners, as well as neighborhood groups and advocacy groups. We have an enormous problem nationwide because of a U.S. Supreme Court decision called Reed versus Gilbert. Reed versus Gilbert, it's decided by the Supreme Court 4.5 years ago, held that sign regulations can no longer be based on content. Your sign regulations are content-based as proposed in this regulation. Your sign regulations also cannot give preference to non-religious activities, and your sign regulations do that, as I explain in my outline. One of the things that I thought I could do that would be helpful to all concerned is to provide enough copies for all of you of a proposed sign ordinance by the International Municipal Lawyers Association, an organization with which I have had significant involvement over the last 40 years. And I think this will help you understand it's very nuanced, it's very technical, it's very difficult, and virtually everybody's got a problem with it, but you have a problem with it like everybody else. So I'll leave you copies of that. And there's enough for each commissioner to have one. As you'll see from my presentation, one of the problems that we see with your regulations is that lack of definitions. Definitions are really important in zoning. You have definitions, but one of the things that changed dramatically from your existing regulations to those that you have now is you've added a provision that basically says, if it's not expressly included, it's expressly excluded. You don't have that now. You have that in your new regulations. That profoundly changes the way the regulations are interpreted. So if you don't specify a use, such as religious institution, a serious question is raised as to whether that use is possible at all anywhere in the town. It appears to us it is not. And it was that change of adding that particular wording, which we find in many regulations, not all, but many, puts you in a position of having to be very specific about what you're authorizing and what you're not authorizing. I made some excerpts of definitions. I happen to be the co-author of the leading text on definitions nationally, and I went into my book and pulled out a series of definitions. We're not recommending them to you for adoption, but I offer them to you as examples of how specific we need to be sometimes in drafting zoning ordinance. It takes work, it takes a lot of extra work, as your consultant will tell you, but it really is essential in many cases, and it certainly is here in protecting the religious freedom rights of property owners. So I'm going to leave you enough copies that you can all have one of that as well. As I said, Frank Fish will be speaking when I'm done, and I have one copy here of his biographical information for your record. And finally, that's two, I think. Is that two? Nope, that's one. Thank you. Plenty of extras. Okay. Save it. I'm not going to read everything that's in here. There's too much detail, but I do want to walk you through it. As I said, I addressed the issues in 4 sections. The first is the Religious Land Use and Institutionalized Persons Act. I cite here 4 different provisions. A violation of the Act requires proof of only violation of one of these provisions, not 2, not 3, not 4, but 1. There's protection against a substantial burden on religious exercise. And there I cite the statute, and all of this, except for my explanatory comments, comes from the Department of Justice website, and I give you that link so you can go look at it yourselves and see what the Department of Justice says, because they sometimes intervene in these cases on behalf of the religious institutions to defend their religious freedoms. But you cannot impose a substantial burden on a religious exercise, and here, by reason of your having changed the definition from your existing ordinance that included places of worship and religious institutions and eliminating religious institutions, you have wiped out a whole lot of religious activities that are reached by the Religious Land Use and Institutionalized Persons Act. So that's what page 1 addresses. Page 2 and the top of page 3 is a continuation of Hillsdale College's religious interest in the zoning. In the middle of 3 is another principle of the Religious Land Use and Institutionalized Persons Act that, in my opinion, is violated by this draft, and it's the unequal treatment of religious assemblies and institutions. This is a small and nuanced point, but it's a big one when it comes to this violation of federal law. As I read your draft, you are creating this new thing called a planned amusement recreation area. It appears to be coincident with Sunny's Place. And in that, and on Sunny's Place website, it says that they can accommodate 500 people in a public assembly. But yet, your proposed regulations prohibit even a place of worship on that land. And you can't do that. You cannot give preference to a non-religious place of public assembly over a religious place. And you call out that places of worship, never mind the issue of religious institutions, which are no longer allowed in the town under these new regulations. You don't allow a church or a synagogue or a mosque or people from them to meet in that district as a use. It's not permitted. The third item under the Religious Land Use and Institutionalized Persons Act is on the next page, page 4, deals with protection against religious or denominational discrimination. And there we talk about the process by which this ordinance has come forward during the time that there's an application pending. And I would like to have all 4 of those applications for special use permits. Let me give you the numbers. 19-012, 013, 014 to be made a part of this record. Again, showing the religious mission of Hillsdale College and the fact that it's an owner property in the community. So, Madam Chair, would you make those records a part of the record of this proceeding for that purpose?
I think you already have.
Well, in substance I have, but I would like the whole record. So on page 4, protection against total exclusion. Again, religious institutions, by my reckoning, are not allowed anywhere in the town now under these new regulations. You allow places of worship open to the public. Well, places of worship, we think, are different than religious institutions in the broader range of things that they do in serving their parishioners and members and in the larger community. And again, I spell out in some detail here what those are, and I won't read it further. I'll leave it to your study. And finally, protection against unreasonable limitation on religious assemblies. Again, this problem with the planned amusement recreation district, but also the total exclusion from the entire town. Total exclusion from the entire town of religious institutions as contrasted and compared with places of religious worship. And interestingly, the way your regulations read right now, subject to your getting a special use permit, and remember, I don't think there's any place in town under your proposed regulations where anybody can establish a church, synagogue, or mosque or other place of worship without getting a special use permit. Every single instance, as I read the uses, is discretionary with this commission. But besides that, the way it reads now, you prohibit places of religious institutions, but you theoretically allow a megachurch. And a megachurch is defined, as you'll see in our definitions book, as a church up to 10,000 seats. You're not going to have likely anything like that in this town, but we've seen them elsewhere. But that's what you allow, and at the same time, you don't allow religious institutions. Next, the failure to comply with state law on the top of page 5. Part of it's the zoning enabling statute 8-2, and I spell out there where I think the deficiencies are. But there's another one that virtually every planner I know, and like I said, I happen to be a planner as well as a lawyer, that virtually every planner I know doesn't even really know exists under Connecticut law. And that's our Religious Restoration Act, which is a lot like the Religious Land Use and Institutionalized Persons Act, but it's a state law. It was Public Act 93-252, which was the state's embodiment of the Federal Religious Freedom Restoration Act. And it provides, and I quote part of it here, it forbids political subdivisions of the state from burdening religious exercise, quote, even if the burden results from a rule of general applicability, except with 2 exceptions. 1, it's in furtherance of a compelling governmental interest, and we cannot discern how prohibiting religious institutions furthers a, quote, compelling governmental interest. And that it's also the least restrictive means of furthering that interest. You do have interest under the police power, of course, the power to protect and promote and preserve the public health, safety, and general welfare. But in order to do that with a religious use, you have to have it to be the least restrictive means. And prohibiting religious institutions townwide, I think people would normally find that not to be the least restrictive means. Number 3 at the bottom, page 5, the violation of the Constitution of the State of Connecticut. I spell out there the sections 3, 20, and Article 7, all dealing with religious freedoms. And then I give you some, again, examples or illustrations, not all the problems in the ordinance, but some of them. And finally, the violation of the Constitution of the United States, and that's principally Amendment 1, the First Amendment, dealing with the free exercise of religion. Again, I reiterate all that I have before about the restrictions on places of religious institutional uses, the planned amusement recreation district, but then I go on to discuss the problem with the sign ordinance in some detail, which I've already touched on, the preference given to non-religious signs, both in terms of the number of days they're allowed to stay up, and the violation on its face of Reed against Gilbert by having content-based regulation, for example, calling out a for sale sign. You can't do that any longer. It's hard to do right, but the International Municipal Lawyers Association, as I said, we've spent a lot of time working on that, points us in the right direction. So those are my principal comments. I'd like to have Frank Fish, our planning expert, speak briefly, and then I'll conclude with just 2 or 3 sentences of wrap-up remarks. Thank you for your attention.
Thanks, Dwight. Good evening, members of the commission.
Good evening.
Usually the lawyer is a little longer. I'm going to be a little shorter. So I'll give Jennifer Roy a copy of my comments. I talked, and I also had a chance to talk to Glenn just a little bit earlier. For many municipalities here in Connecticut, I play the role that Glenn is playing for you tonight. But again, I'm Frank Fish. I'm a principal of Bucker's Fish and Jock Mart's BFJ Planning. We have offices here in Stamford. I've done about 25 or so POCDs and consequent zoning amendments here in the state. But I want to talk to you tonight just about this 3 things in the proposed zoning that you have before you, and try to be just very straightforward on those. But one of them comes out of experience with where I was a municipal planner with a very noted case law on the Religious Land Use Institutionalized Persons Act, or RLUIPA, and that is a case called Westchester Day School in the Village of Mamaroneck, New York. It's Westchester Day versus Mamaroneck, and it's an important case, and I just want to go over these 3 things in your code. I think they're fairly straightforward and actually fairly straightforward to rectify at least these items, and that is what I noticed in your code is your table of permitted uses, Schedule B, which includes the A residential district where Hillsdale College is interested in parcels of land, and it lists specifically right now in the current code places of worship and religious institutions.
Mm-hmm.
So it lists both in the current code, and that's permitted by special use. But the proposed wording of the new code just simply doesn't have religious institution. It just lists places of worship. And that may be, I'm not sure all the reasons for that, but the new code simply lists places of worship. And again, that's the only thing it lists. So it dropped the 4 religious institutions. As Dwight in the college has pointed out to you in other submissions, the term religious institution protects a number of religious uses that are not necessarily encompassed in the words places of worship. So to adopt the new code with just places of worship and dispense with the former, we think this unnecessarily restricts religious exercise without a clear purpose. Now, this could have been just a minor oversight, quite frankly. We don't know the reasons for this, and they may be totally innocuous. However, they are under the religious, under RLUIPA, the Religious Land Use Institutionalized Persons Act, very important, because the case in Mamaroneck, land use case there, the court was very clear, and it really says that in this case, the court says that protecting the religious exercises to be construed broadly, not narrowly, broadly, and to the maximum extent permitted by the terms of RLUIPA and the Constitution. I happen to represent the village. I was on the losing side of this case, so I learned certain things in the case. Dwight has mentioned some of them, but I think it's important to mention to you that this is kind of important for every town, every municipality. There's three things about this RLUIPA case, which the judge sort of impressed on me, anyway, in the words of the case. You can't treat a religious institution on less than equal terms with any other place of assembly. That's very important. Two, you cannot place any substantial burden on a religious institution. And three, you must ensure that any restriction stemming from a compelling government interest, and the government does have compelling interest occasionally, it's got to be done in the least restrictive manner. So those are the three things. You got to treat religious institutions as on equal terms with any other place of assembly. You can't provide any substantial burden on the free exercise of that institution for religious purposes. And then any restriction put on it must have a compelling reason, and it has to be the least restrictive way you can do it. Mamaroneck we tried very hard, but eventually the judge felt that we had failed in that. And that failure also cost the municipality all the legal fees involved. In the Mamaroneck case, it was several $1 million. So it's an important lesson I learned in any case. So that's the first thing in your code. You currently have in the code two things: places of worship and religious institutions. So that's the words of your current code. The proposed code only has places of worship. So we think that can be easily solved by staying with your current code wording there. I don't know why not. In other words, I think a straightforward thing to do. But there's a second issue with the proposed code, and again, this may be not conscious, you may not have gone through it or thought of this, but the second issue is the code's purpose section. It doesn't have any mention of the freedom of religion, exercise, or places of worship or religious institutions. And by the way, it doesn't have to. I'm not saying it has to. Most codes might not have that. But for one thing in your current code. Your current code in section 214.91, it's called permanent public uses. When I read it, I saw in the current code, your section 214.91, under that section, permanent public uses, subsection D, churches are recognized as permanent public uses. In other words, churches are recognized as being in public benefit. And that's important in your current code. And so I would say in the purpose section of the code, you don't need anything there because your current code has that. But I can't find that section in your proposed new code. Now, there may be something there that, your proposal was about 200 pages long, so I could have missed something. But one way to remedy this is to just recognize religious uses and institutions in the purpose section. And that would solve the RLUIPA issue, because RLUIPA says that you may not exclude religious institutions from any zoning regulation. So that's the second issue. It's a minor issue, but I think the change, again, it may have been inadvertent, but there's a change between your existing code and your proposed code. I think it's easily corrected. And then finally, your regulation now contains a section 1.4 in the beginning, and that is, and I see it in a lot of codes. But its use is prohibited if not permitted. That's an important change. That's an important new section of the code. Now, because only a place of worship is now listed in your proposal, and not a place of worship and religious institution, the place of worship has a narrower focus in my mind, whereas a religious institution could include the broader social, education, cultural functions that go with a place of worship, for instance, a church. So I don't see any reason for the town to risk any possible confusion here. I think the solution is clearly just to allow both a place of worship and a religious institution. And that's what the current ordinance does. Your current ordinance allows that now. So we think that is the preferable thing to keep that. And so I think it's a very simple type of 3 issues I wanted to make, and I have a copy of this for you. So.
No, I didn't bring it in tonight either.
Thank you, Frank. Let me conclude by, maybe should have mentioned at the outset when I introduced you to Dan Dalton sort of remotely. He's off in San Antonio tonight. The last time he and I worked together was the Chabad in Litchfield, where I represented the Chabad, did the public hearings, and he did the litigation, having recently won that case in the Second Circuit. It would be so much better to fix what you have. Right now, the purpose, as your consultant will tell you, and Frank Fish and I would tell you, is that the purpose of the public hearing is to elicit comments and concerns and make recommendations for amendments. And that's what you've heard from the public previously, and you've heard from us tonight. However, the changes that we're suggesting are so substantial that it is my opinion that you can't make them in the context of the record of this hearing without a violation of the public notice requirement, because people have read the ordinance as it is, including the sign ordinance and all of the rest of it that I've touched on only briefly. They came and they presented, they went home, they think they're done with it. If you change it dramatically, you have a notice problem. That's my opinion. You have a town attorney, you have a consultant, you can ask them. But if I were representing the commission, I would tell them there's no way that you can make the wholesale changes that you need to make to avoid the liability that you have under the Religious Land Use and Institutionalized Persons Act, under the state statutes, under the state's Religious Restoration Act that I cited, under the state constitution, the U.S. Constitution. We respectfully request the commission consider withdrawing this proposal, sending it back to a workshop, and I have the commitment of our client to work with you directly and with your consultant, with the help of Frank Fish and anyone else we need to enlist, to get this proposal, which is a good part of the way there, but still short of where it needs to be, in a state where there won't be a controversy publicly over the provisions. Just a restart, we'll work with you. We'd love to do that, rather than all the other potential paths forward that arise out of this type of controversy. So Frank Fish and I are available to answer any questions or hear your comments, and I thank you for your attention. It's a difficult job that I have to do to create a record, because we are a record appeal state, but I believe in being direct and just as direct as I can be, and I'm sorry if that's upsetting to any extent to any of you. Thank you for your attention.
Thank you.
Thank you for your comments. Glenn?
I guess I'll say I'm honored to have my esteemed colleagues in the room tonight, but I also respectfully disagree with their conclusions and opinions. I think that the regulations are something that we will need to take a look at. I think they've raised some very serious issues here for us to take a look at. I think we should share these with the town attorney and get his input. I think the operative lines here, there's 2 lines in the regulations which are really the most significant. It's 3.2D2 and 3.
Yep.
The language which Mr. Fish identified in section, I think it was 98 of your current regulations, was changed from churches open to the public to a place of worship open to the public and put into the table. and permitted in all the zoning districts. So I think there's a lot of blowhard going on about what is or is not permitted in the regulations. The line right below that says nonprofit institutions, which is allowed in 3 of the 4 districts in town. Nonprofit includes religious institutions. So it's a broader term, which doesn't limit or exclude. So despite all the constitutional claims about, the commission's activity, et cetera, I think there's much ado about really 2 lines in the text, which I believe cover these issues adequately and would permit an application for these types of issues to come forward. The issue of sign regulations, I think we had a conversation, a workshop with the town attorney on sign regulations, the challenges and difficulties we have with the Reed versus Gilbert decision, and also we talked about the Milton case in terms of the limitations and guidance that provides to communities with regard to sign regulations. I think I'm not aware of any discrimination on religious signage, but I think it's something that we should take a look at to make sure that we do not. The issue was central to the Reed case. The church was singled out for enforcement activity, and pastor, I guess, is the right word in terms of what happened in that particular case. And clearly not our intent in some ways in terms of addressing that. So we should take a look at the regulations. Claiming that the entire set of regulations is constitutionally invalid, et cetera, is something we should talk to Carl. So I appreciate the input tonight. I'd just like for the record to point out and indicate that I think the uses, our intent was to address and include. The wording is slightly different than perhaps what they would like to see, but I think those issues are addressed and we should ask Carl. So I just wanted to follow directly rather than I speak for the...
Have you signed in? Yeah, you can sign in. We make our comments at the end of the public hearing.
Oh, can I do that?
Yeah.
All right, Bob Chester, 19 Mansell Road. I'm not a lawyer, layman, and I just heard, what I heard, and I don't think it, I don't know if the term was used, hot air, but if you go to Webster's Dictionary and you look up what place of worship is, to keep it simple, and religious institution is 2 profoundly different meanings. So I think that to remove religious institution that impacts an existing applicant is very problematic, and I don't know why that wouldn't have been raised by the consultant as one of the primary concerns. And that's, as a layman, not a lawyer, but, I know that simple definition for those 2 meanings are substantially different on what that parameter extends to, and to change the law on an existing application that removes religious institutions seems like
We're
problematic.
not going to affect any current application.
That application is already in, so it would be under the old regs, not the new regs.
Oh, okay.
That future regs to be adopted.
Okay,
So
because I heard that and I was
it doesn't
like,
affect them.
Okay,
You're held to the regulations that are in place when you apply.
all right, thanks.
Would anybody else like to address the...
Good evening. My name is George Schober. I live at 98 Rocky Dundee Road. I have several comments regarding various aspects of the regulations. The first, and probably the lengthiest discussion that I want to enter into here is the winery, distillery, brewery. And I've heard a lot of comments regarding the wineries, and most of them do seem to be presuming that the winery or a winery will be on Mountain Road. And I want everyone who has indicated that they support a winery and people live all over the town, and they live in the A district and the A1 district. A winery can be located under the proposed regulations on any piece of land that contains at least 10 acres anywhere in the A1 district, not the A district. But for those people who live in the A district and think a winery or a brewery or distillery won't affect them, it very well might, in a number of ways. First off, every boundary on these A districts, which there seems to be no rhyme or reason as to how they're located around the town, but those border A1 districts. And so when and if a winery is situated in the town somewhere, it very well may be on that border. And for all of the people on Mountain Road, you have residences that are in the A district, and you're going to have the drunks coming down off the winery after attending festivals and weddings and things up at Worthington Pond, coming down the road at 50 miles an hour or 60 miles an hour, which the average speed limit, now that the road was so nicely improved, is probably 45 to 50. You're typically, I don't know what the speed limit is, it doesn't matter because nobody follows it, but you're tailgated at 45, going up as well, by the way. So I understand that there will be a hearing if there's going to be a winery there, if a regulation is put into place, and there'll be a special use permit. I want the residents of the town to understand that a special use permit will not protect them. It is, a special use permit will only attach, more than likely, certain conditions. If Connecticut state law states that where regulations permit the use at issue, a conclusive presumption arises that the use per se cannot adversely affect the zone in which it is to be conducted. It's allowed basically as of right, and all you have to do is meet certain conditions. And in some cases, there are no conditions put on special use permits. So I just think that those few people, and it's not a lot of people, not in a town of 10,000, to get 20 comments or 30 comments in favor of a winery by people who have no idea that this winery may be situated by them because all it takes is 10 acres, that's not a lot of people. And for those people who live on Mountain Road and have had to put up with what has gone on at that site, it's not fair to them to have a permit that is in place for weddings and other outdoor functions and now allow alcohol to be served there, because that's what's going to happen. It's going to be piggybacked. I heard that there are, I think, 40 wineries in the state. That's enough. Summers doesn't need one. Just because other towns have one, we don't need one. We're doing away with religious institutions, but we're going to have wineries. Which brings me to another point. We're now going to allow dog kennels in a residential zone. Now, did somebody ask for that? But the regulations allow commercial dog kennels in the A1 zone. So what we're doing is we're getting rid of religious institutions, but we're bringing in the nuisances, the wineries, the dog kennels. I mean, are we missing a few? Did somebody ask for that? I haven't seen anything. Sometimes things go on behind the scenes and you don't get a full picture of everything. So in order to try to get a full picture, on November 21st, I hand-delivered a Freedom of Information request to Bud Noor. And in that request, I asked for all emails, all drafts, and all notes pertaining to the revisions of the summer zoning regulation. Now, I've received all the drafts, which were all public, the draft regulations. There's been 5 or 6 of them, and there's been public comment. I've had meetings and workshops. I've received 0 emails, and I was told that I won't be receiving notes, that the town does not have to turn those over. Well, that's not what the law says. So, once again, I filed, I know, is that upsetting, Carl?
No, it's not, George.
I filed a complaint with the Freedom of Information Commission, and I'd like to enter that into the record tonight, the complaint, as well as a copy of my Freedom of Information request, and the email I received that says I won't be receiving any notes. And I would strongly urge the commission to not adopt these regulations until it complies with the Freedom of Information Act and turns these documents over to me, so that I can review the documents, so that my clients can review the documents, and we can determine why certain things are or are not happening with these regulations. Now, I also have a few questions about the process of hiring planometrics for this. Was there an RFP put out?
We are taking in comments, we're not really answering questions at this time. If you have a question, we'll take your question or your comment, and we'll address it.
Okay? Were there, if there was or was not, were there other bids?
It was about 18 months ago, 2 years ago. I can say I don't recall, but you will take in your comments,
Right.
Attorney Schoberg, and we will address them.
Thank you. So my next question is, were there other bids? I'd also like to know how much planometrics is being paid for this, and to ensure that I receive that, although the town doesn't necessarily follow the law, I'm submitting another Freedom of Information request for all of that information to Mr. Knorr. And I would hope that I receive that information in a timely fashion. That will conclude my comments. Thank you.
Thank you.
You have something new?
Do you have something new to offer?
Yeah, that's a question.
We are taking in new information tonight.
Oh, you got a lot of it,
We
didn't
got a
you?
lot of it.
Yeah,
Oh,
we did.
Who knew?
Jeff Lipton, 452 South Road. I just have a question which you can answer later. But currently, from what I'm hearing, is that Worthington, the property up there allows for wedding receptions to take place. I'd like to know if that's a permitted activity that can go on up there right now. Because I was going to say, if it is, I'm sure they probably allow BYOB because that's not regulated. If the winery was up there and they were serving wine, they're not serving alcohol. The winos are a lot less problem than the drunks that are drinking hard stuff. So if it was actually turned into a winery in your regulations and they're allowed to consume, they would not be allowed to have that and BYOB. So the only thing they'd have is wine. Hell of a lot better having wine than having a whole bunch of vodka. That's all.
Thanks. Thanks, Jeff.
Thanks, Jeff.
Is there anybody else to add anything? No? That anything?
What was that?
I just wanted to mention to you, to the commission, after reviewing further, with some questions about drive-throughs, and I'm not sure if it was just omitted in error from the commercial zone to the village business. Not regarding the request to remove the separating distance. When I received that request and looked at the new draft regulations, I realized that did carry over from the commercial zone to the village business, which I just wanted to address the commission if that's your intent or not.
No, it was not our intent.
So, okay, so I would just suggest that maybe that's discussed with Glenn about carrying that over to the village with the current separating distances for food service and
Correct.
food and things.
Correct.
So we've gotten a lot of new information this evening, and we don't have our counsel here tonight to advise us. So we're going to take this information in and pass it on to our counsel and probably continue this public hearing, I would think, because we have to take in information from our council to address these gentlemen over here.
And Mr. Schober, too.
And Mr. Schoberg comments. Glenn?
Yeah, I think I
Yeah.
would support that effort on the part of the commission. Under the law, you have to close the hearing within 30 days. And we do have the ability to continue. We're not really aware of Carl's availability.
Mm-hmm.
So I
Right.
think what we should do is continue the hearing to a date uncertain at this time. And as soon as we can get a hold of Carl, publish on the town's website what that date will be. I think the main purpose of continuing the hearing is to get Carl's input with regard to some of the allegations raised here this evening. And so we understand those particular issues and schedule that date as soon as we can for everybody's interest.
Yeah. So 30 days is probably,
30 days from January 13th would be the commission, I believe, does have a regularly scheduled meeting between now and
we have,
Yeah,
we
we
have
do,
another
but it's
public hearing.
a little jammed up.
I understand.
We are
My goal
totally-
would be is that, my advice to you would be, given the time frame in the statute, that, once we know from Carl his availability,
Mhm.
with the commission's work schedule, if it was in that 30 days, then we
Yeah.
can schedule that and we're good.
Yeah.
If it's not within 30 days, then at your regularly scheduled meeting, simply put a motion on the agenda that you would continue the hearing over to this new date.
So this would just take us till February 12th,
Correct.
right?
Correct.
February 12th.
The math is right.
'Cause it's
Whatever
30.
30
Yeah, no, but we're gonna meet again on February 3rd.
Understand. So I think that we will be able to schedule a date and comply with the statutory guidelines, either within the first statutory period, or we can give ourselves an extension. But I think it's important that we talk with Carl.
Right,
Yes,
right,
so we definitely want to extend it for
correct.
30 days. Keep it open.
I make a
Continue.
motion to extend the public hearing to the 12th of
It's a date
February.
uncertain at this time.
Well-
Well, we can continue it, and then we'll meet with Carl.
Oh, we're gonna
In the
continue it
interim-
to a date uncertain, okay.
Like,
I think
can we
Carl, I think-
continue it to an uncertain date? Do we have to give a date? Thought we had to give it.
No, we just said, I think we can do what he said.
I mean, of course,
But
I'm
I'm
not,
not an
Your next
attorney.
meeting, Commissioner.
February 3rd.
February 3rd, but that's
It's a regular meeting, so we could.
It's a regular
Yeah.
meeting, February
we
3rd.
could put it,
We have two public
Why don't we
hearings on the
continue to
agenda.
February 3, which is a date certain, and if Carl is available that evening or not, we can continue the hearing from February 3 to a date after that. So I think the most important thing is for us to bring this new information, get Carl's input on it, and we can continue this hearing to February 3rd. We may not open the, just so the public is aware.
okay, may not open it, just may continue
February
it.
3rd is the date of the next commission's next regularly scheduled meeting, so we can continue it to that date to continue this type of discussion about procedures. There may or may not be discussion that evening. It may occur the date after that. It depends on the town attorney's availability.
Yeah, we may be extending it again at that point.
Understood.
He'll probably
as soon as
be,
we can.
he will
He'll be
probably
here.
be here the 3rd.
He will be here the 3rd.
Understood, but that, I understand your agenda's full. Got it.
Yeah.
10-4.
So I have a question, I'm sorry, I'm confused. So will the public be speaking at February 3rd or not?
Not on this
Not on this,
topic.
it's
It's
a different public, it's a different public hearing. It's not a public hearing regarding the regs.
Well, Jill, I think
But
the suggestion is to
continue
continue the
that-
public hearing to February
that-
3rd, at which case you can determine to open it and allow people to speak, or not.
yes, on February 3rd, we have another public hearing scheduled.
Two.
Two that are probably lengthy as well. And at that time, we may choose not to open this, just extend it again if time doesn't permit, and depending if our council has had time to review this.
But it may open on February 3rd. This may continue, there may be discussion on the regs on February 3rd. What I'm
Yep.
saying is, I think it would be much fairer to the residents if they knew whether they needed to show up for February 3rd to what is already going to be a packed room, as it was last, public hearing regarding
Yeah,
the application before it. So, that's all I'm saying, is that
I mean, you'll be here anyway.
I will, but other people may not want to. They may not want to sit through two public hearings to only find out that then you're not going to talk about your regs.
Go ahead, Glenn.
I think the only thing I may add, it may or may not help this conversation, I think if I understand the commission's desire and intent here, is we would like to continue the meeting to a date where we know the town attorney can be here, we devote our full attention to this issue. Unfortunately, we don't know the town attorney's availability, so for procedural reasons, we're continuing it to February 3rd to allow us to then make the call on February 3rd what that date will be. So I think it's fair to say that there is no intent on the part of the commission to have a substantive discussion on the zoning regulations on the night of February 3. However, by that evening, and perhaps even earlier, the commission will have figured out an alternate date that we will then be back and pick up where we left off today. Does that, I think, help?
I think that does help. So in other words, there'll be another night where this discussion is continued.
Correct.
Okay, great.
Don't adopt.
And it may occur within the statutory window for public hearing, may occur
Yeah.
after that. We're gonna work that out perhaps
Can we?
tomorrow and then.
Here, you want to ask?
Can I just clarify, so the
Wait.
30 days, more than likely, we'll just.
You know, I gotta say, this is a public hearing, and anyone that speaks really needs to state their name, their address, and speak. Because
At the microphone.
we're being recorded.
All right.
This is important.
I apologize. Bob Chester, 19 Mansell Road. So in 30 days, we'll just come and listen, and you will probably respond to a lot of the questions that were generated here, correct? So that we would learn the reason and motivation behind eliminating religious institution from the regulation.
I think the purpose of the continuation is to allow the town attorney to provide his commentary based on what we've heard this evening.
Okay, so we will learn then the reason why religious institution
You may
was
or may not.
eliminated from the existing zoning regulation.
You may or may not.
Okay, thanks.
Do you want?
Would it be acceptable, given all this concern over our timing, et cetera, to close the public hearing, vote to not adopt at this time, and then start over, or not?
That is an option which is available to the commission, so I think the commission has
I mean,
two
it's just,
And they'll be available to us.
knowing where we're headed with the other things on the horizon, without numerous extra meetings, which we are willing to do, not so sure we're gonna get right back to this.
Understood. So I think the commission has two choices.
I mean, there are a number of issues that were brought up tonight that seem as though they're gonna take some conversations.
I think that's the purpose of having a meeting that Carl can be at. Carl may agree or disagree with some of the
Right.
Yeah.
input this evening, and there may be other issues. So I think the commission has two choices, one of which would be to close the hearing tonight. Sorry.
Yep.
Continue the hearing
Continue the
tonight
hearing tonight.
to February 3 for the purposes of deciding next steps.
Right.
On February 3, you could take the alternative action or
Which would be to,
continue it, et cetera.
yeah.
The other choice of the commission would be to close the hearing tonight, or simply make a motion to withdraw the application, in which case the hearing is functionally closed and there's no application pending, and then the commission could start the process again when they felt the time was right. I think that we're in mid-dialogue at the present time.
Oh, I know.
Yeah.
So I think my sense would be, the decision to withdraw rests with the commission. Hear what Carl has to say, and Carl may advise you to do that. Or Carl may say,
Okay.
just continue the hearing, and you have 65 days after the close of the hearing. So don't throw that
Yeah.
out. So I
Yeah.
can't tell you what to do. I think those are your choices.
I think we should continue it till February 3rd and get Carl Landolina's input and possibly, Evan Siemens' input, and
more from
then
Glenn.
we'll see, and more from Glenn, and see where we end up on that night. Whether we,
So moved.
second, Carl made a motion, Paige seconded, all in favor?
Aye.
Aye. Motion carries to extend the public hearing until February 3rd, 2020, right here in the town hall, 6:30.
Does that work for you?
Well,
Glenn?
do you want to make a motion
that-
to adjourn?
Any of that work for you? Motion to adjourn?
Carl made a motion, Paige second, all in favor? Aye. So that was